Hello and welcome to the first in a series of webinars based on the products that HoneyPro offers you and your clients. My name is Thomas Kendrick. I'm the Head of Legal Services for Honey Systems and for the HoneyPro software. This webinar will be based on wills and intestacy, with particular focus on wills being the product. So what is a will? It's quite a simple question. A lot of us already know what a will is, what it does, but in this webinar, we'll drill down into what it exactly does and what a will can contain, how it protects an estate, and so on. So first things first, a will is a set of instructions that is written by someone stating wishes on how to distribute their wealth upon their death. So with a will, it has to be written as a set of instructions by the person whose assets there are, and the will has to state where they want those assets to go. Wills must be in writing or typed out. That would be physical copies. At the moment, digital wills aren't valid. There have been certain cases where a text message or an email has been classed as a will, but these are very few and far between, and it's not good service to leave this down to chance. The will must be made by the person disposing of their assets. This person is called the testator, and it can't be made by anyone on behalf of the testator. The will must be signed by this testator and witnessed by two independent people. Now, these independent people can't be family members and they can't be any beneficiaries benefiting in the will, just because it increases the likelihood that the will be challenged in court. Before we move on, it's important to learn a new term, because the term estate will be used throughout this webinar. The term estate is a collective term meaning all the assets. So in common language, an estate can be a grand property estate, it can be a council estate, but for estate planning, a person's estate is their wealth. So who are involved in a will? Essentially, who are the actors, who are the people who are named in the will? So earlier I mentioned about testator. The male version of a testator is testator. The female version is testatrix, and you'll see that becoming a theme throughout these terms. And the testator is a person who the will is for. So you'll see on the front cover of a will, it says last will and testament of, for example, Mr. Bob Smith. In that circumstance, Bob Smith is a testator. The next people are executors, or if they are a female, executrix. These are the people who are appointed by the testator to distribute the estate as per the wishes in the will. These people are responsible for applying to the probate registry as well to get the grant of probate. And the grant of probate will state whoever the executors are within the will, and they're the people who've got legal authority to distribute the wealth in the will. Trustees. Usually, in a lot of cases, trustees are the same people as executors within the will, but it is possible to have separate trustees to your executors. The trustee's job is, after the executor has finished up their administration process in the will, the executor hands over certain assets to the trustees to hold on trust within the will. In a standard will, you won't see many trusts, but the most common being an age of attainment. This age of attainment can be any age over the age of 18. And if the beneficiary is under the age of this attainment, then the trustees have to hold the assets on trust for them until that age. Guardians. So guardians, same definition as in family law. Guardians are the people who you appoint to take over the parental responsibility of underage children. In some cases, within the will, you can state the underage children can be between 16 and 18, but that's only for gifts. As I say, the guardians in a will have the same definition as in family law, which means if you pass away and you have a 17-year-old child, that you'll have to have a guardian if there's no other person who has parental responsibility. Legatees. Now, legatees are the people who inherit specific gifts from the estate through the will. So you'll have gifts in the will that state something along the lines of, I give the sum of £20,000 to my son, and this son, for the purposes of the will, is called a legatee because they're inheriting a legacy. Beneficiaries. Now, beneficiaries can be a broad term. The terms legatees and beneficiaries can be quite interchangeable, but for our purposes, beneficiaries are the people who inherit the rest and remainder of the estate. This is after all the gifts have been paid, after all of the debts have been paid out, after all the assets have been called in, and after probate has been granted. Witnesses. Witnesses are the people who, as the name suggests, sign a will to say they've seen the testator signing the will themselves. We'll talk about the requirements of these witnesses later on, but witnesses have to physically be there to sign to see the will being signed. During the COVID pandemic, the Law Society relaxed rules, so you can video witness a will, but that witness still has to sign the document at some point. Some other terms to remember. So throughout the will, throughout your estate planning process, you'll come across these terms, and it's very important to learn them and to incorporate them in your everyday language. Nil rate band. So the nil rate band, for those of you that aren't already tax advisors, the nil rate band is the amount a person can give away during their lifetime and also through their will before inheritance tax becomes payable. So the current nil rate band allowance as of 2021, and it's frozen for another 5 years, is £325,000 per person. So if I had an estate worth £400,000, £325,000 of that will pass to my beneficiaries tax-free, but I would have to pay inheritance tax of the remaining £75,000. At the moment, the inheritance tax rate is 40%, so I would pay 40% of that £75,000 in inheritance tax. The term issue is a legal term, which simply means direct descendants. So you will see this term a lot within our wills because it is a legal term. It's come from our president. So if you have any clients asking what that term means, just simply say, change the word issue to direct descendant or to children, and it makes it a lot more easier to understand. A grant of probate, it's a document from the probate registry which shows who the legal authority to distribute an estate within a will. So the executors, as said earlier, are appointed through the will, and they're the ones who will apply for this grant of probate. They are the ones who will be named on this grant, and they're the ones who the probate courts have given legal authority to start administering the estate to. Letters of administration. This is where an estate doesn't have a valid will. So the estate is in fact called intestate. If you have an intestate estate, obviously you can't apply for a grant of probate because you haven't got a valid will. In this case, the probate registry will then appoint an administrator, and the administrator will distribute the estate as per the laws of intestacy. Which brings on to our next point, the intestacy rules. So these are rules completely made up by the government, and they dictate what order the estates are distributed in. So if I die leaving a spouse, then they inherit my estate up to a certain point. At the moment, that statutory legacy is £270,000. The rest remainder is then split between my spouse and my children, if I've got any. So without a will, your children could inherit half of anything over £270,000, which you might not have wanted initially. Intestate, again, is an estate without a valid will. And the term trust, we use this term quite often, and a trust can mean a physical document. It could also mean an express trust within a will. So the will itself would have a clause which says, I give to the trustees of this will. Or the will could have an implied trust, such as an age of attainment that I mentioned earlier. But in essence, a trust is where assets are given to someone to keep hold of, subject to duties for the benefit of another person. So a trust could simply be, I want you to hold on to this painting for me, and upon my death, I want you to give it to my son. That is a trust. What makes a valid will? So if you are helping your clients fill out the customer portal and helping them sign the will, then this is a very important section for you. So a will has to be drafted as instructions. So each clause has to start with an instruction, such as I give, I instruct, I appoint, or I revoke. The will is essentially, as I said before, a set of instructions from the testator to the executors, telling them what their wishes are. There has to be a certainty of gift within a will. So if you provide a choice of a gift to someone, then sometimes it'll be fine, it'll be valid, depending on what the gift is. But most often than not, it's invalid, simply because it's ambiguous. You can't ascertain the testator's intention. From well-known case law, there's a well-known example which provides a gift of a choice of racehorses. Now, if I was a beneficiary in that case, I would pick the most expensive racehorse. But the will doesn't say the most expensive racehorse, it just says a choice of horses, which means that you can't ascertain what the testator's intention was. So it's very likely that will be challenged and become invalid. Certainty of beneficiary. Quite simply, the beneficiary has to be identifiable. If the beneficiary isn't identifiable, so the name's misspelled, the name is missing, they've got a name which there's two people of. So for example, I know two John Smiths, but I haven't provided an address for the one that I wanted to give a gift to, then it can fail, simply because you can't ascertain the intention of the testator as to where that gift's going to go. The testator has to be at least 18 years old. So in England and Wales, the legal age of legal capacity is 18 years old. In the case of wills, there is one exception. If someone is over the age of 16 and is in the armed forces, they can have a will. But in most cases, it's going to be at least 18 years old. The testator, again, this goes without saying, has to know what a will is. If the testator doesn't know what a will is, then how can they enter into a legal agreement such as this? And we'll talk about mental capacity to know what a will is a little bit later on, but in summary, the mental capacity for making a will comes from the case of Banks versus Goodfellow, which is an 1870 case, and it's still used to this day. So it's good case law. That case outlined 4 tests for someone who will have the mental capacity to make a will. And that test asks, does the testator understand the nature of the will and what the will's effect is? Does the testator have an idea what constitutes their estate? So our system, for example, asks what is in your estate? Do you own a house? What's the estimated value of this house? What's the value of your full estate? If they're able to answer those, then that's one part of the test ticked off. The third part is a testator aware of the persons for whom he would usually be expected to provide for? So this is essentially the testator or the client knowing who they should provide gifts to within their will. So under the inheritance provision for Family Independence Act, 1975, you have to consider your close family members, such as spouses, children, and people who are financially dependent upon you immediately prior to your death within your will. If you don't consider them and you don't have a good excuse to exclude them, then they can make a challenge against your will for a reasonable provision from it. And the last test in Bankers is a Good Fellow is a testator free from any delusion of the mind that may inhibit their ability to understand what the will is and why they should benefit the aforementioned people. Now, this can be quite hard to prove, especially in cases where people have early onset dementia, have been diagnosed with Alzheimer's, or even at the moment of signing the will, they're even drunk. So common sense prevails here. So if they do have a delusion of mental functioning, then you've simply just got to answer those questions that said before. So if they can answer what a will is, if they can answer who they want to benefit, and if they can answer what parts of a estate they're giving away, then usually their delusion of mind doesn't impact their ability to understand what a will is. The will can't have any contradictions within it. So you can't give the same gift twice. You can give certain shares of a gift to more than one person, but if you give one gift to two different people within a will, it's more than likely that both will fail. The will, again, common sense here, has to be signed by the person who's making it. So the testator or testatrix, they have to sign to say, these are my instructions and this is exactly what I want to happen. Like I said before, signature has to be witnessed, and there has to be at least two people that witness the signature. Now, when we say witness, it means physically see the person signing the document, and also they have to sign the document themselves as a witness to say that they've physically seen the signature being made. As well as this, legally, if anyone else is within that room, has witnessed the signature being made by the testator, they are legally revoked from inheriting from that will. So if you sign your will in front of your spouse, then someone can claim that they've witnessed your signature, and witnesses within a will can't benefit, even if they're named as beneficiaries. So it's a good idea if you are having a signing with a customer for any reason, asking the beneficiaries that might be there to leave the room whilst your client and you and another witness sign the will. With witnessing requirements, again, the witnesses should be independent. And as I said before, if the beneficiary witnesses a will, their gift will fail, and they can either be physically there to be a witness, or even if they sign the document, they can't inherit. Why does everyone need a will? So we keep banging on about how a will is important, and having a will, not having a will can be the end of the world. But why do we say this? So with a will is the only way to make sure your wishes are carried out. If you don't have a will, then the government makes that decision for you. And I know I'm not alone in thinking that's a bad idea, especially with people like Boris Johnson possibly in charge for the next coming few years, where he can change the rules at a drop of the hat. With a will, it can be quicker and cheaper to administer your estate. So simply with a will, you've got all your wishes recorded. The only thing your executors will need to do is call in all your assets, pay your liabilities off, and send the will to the probate registry. And the probate registry will then send them back a grant of probate to say, yeah, carry on. This can be a lot cheaper than without having a will, but we'll discuss that later. Within a will, you can also appoint the people who you trust most to distribute the estate. So if you have a complex family situation and you don't want your estranged child to have anything to do with your estate, the only way to make sure that won't happen is with a will. This is quite a uncommon piece of knowledge, but some life insurance companies and mortgage companies offer a better rate if you already have a will in place. It's like having car insurance and saying you've got a dash cam. There's an added level of protection there. So some companies will offer a discounted premium. Some mortgages will offer a better interest rate simply because in your will, it says you have to pay back your liabilities and they know they're going to get the money back. Lastly, for a will, unmarried partners, friends, and charities aren't legally entitled to anything in your estate if you don't have a will. So if you've got any wishes where you want your partner, who you live with, who you love, to inherit anything from your estate, who you want to protect, you have to have a will. The only time that they can claim against your estate for anything is once all the intestacy process has been finalized and they have to bring a claim to court. So it can be messy, it can be long drawn out process if you don't have a will. So without a will, which is essentially on the flip side, your wishes can't get carried out. So your estate has to be distributed as per the laws of intestacy. No one can have any flexibility with that. They just have to do what the government says. If a person doesn't have a spouse, doesn't have children, doesn't have siblings, doesn't have parents, no grandparents, no uncles or aunties, no half uncles or half aunties, then the government inherit your full estate. And I don't think we all want that. We have an application for letters of administration. So before I said a letter of administration is a grant of probate for an estate that doesn't have a valid will. It costs more to apply for and takes a lot longer than a probate application would ever do, simply because the beneficiaries and the probate registry decide on who the administrator is, and people can object to that. So if one child is named as an administrator, then it can cause a bit of friction in the family. And from personal experience, that results in a claim in the court. Again, some life insurance and mortgage companies won't insure or lend to those who don't have a will. It's a very niche market of those that don't do that. But you'll find that if Compare the Market decide to have another section to their quote that says, do you have a will? You'll find more insurance companies would pop up in your quotes if you tick yes than if you tick to no. And lastly, again, unmarried partners can't inherit. Same with friends, same with charities, because your estate has to go through laws of intestacy. How to read a will. Now, I'm not going to bore you with finite details of each clause because simply you don't need to know them. In a will, it can be quite daunting to read the legal jargon, to read what goes first, what goes second, what goes third. But quite simply, the hardest part about reading a will is the terminology. Get the terminology down and it can be very easy from then on. Once you do get the terminology down, then simply read the will as if it was a story. So quite chronologically, clause 1 happens first, clause 2 happens next, clause 3 happens next. And that is essentially exactly what happens in an administration process. So from a practical point of view, you appoint your executors first. Those executors give these gifts. Once they've given these gifts, then they give the rest remainder to these people. Clauses in a will. Again, I'm not going to go into finite detail, but within a typical will, these are some of the outlined clauses. So the first clause in a will is usually the revocation clause. This clause would usually say something along the lines of, I hereby revoke all former wills and testamentary dispositions made by me at any time. It's also quite common for people to have wills in multiple countries. So proper care is needed if your customer does have a will in another country, because the standard revocation clause could revoke that foreign will. If that does happen, if you know of any of your leads in your clients that do have foreign assets and have got a will in another country, let me know and I'll go in and amend the revocation clause so it doesn't revoke the other will. For the rest of the clauses, just like I said earlier, you can read it as a bit of a story. The next clause after the revocation clause will be the appointment of the executors and trustees. Once they've been appointed, you can appoint reserve executors and reserve trustees who will step in if the original ones can't act or won't act, because executors and trustees can stand down. The next clause is usually appointment of guardians or reserve guardians for your underage children. But again, this will only appear if you've said you've got children under the age of 18. The next part is specific gifts. So these are gifts that you give to specific people, hence the name. And the gifts can be assets ranging from £1 upwards to any sum of money, or even items such as your bed or a piece of jewellery. In my experience, a lot of gifts have been given quite strangely, but at the end of the day, it's a testator's wishes. The next part is residuary estate beneficiaries and reserve beneficiaries. So these are the people who inherit the rest and remainder of the estate after all the gifts have been paid, after the debts have been paid, and after all the assets have been called in. You can appoint reserve beneficiaries. So if you decide you wanted to give the rest and remainder of your estate to your spouse, you can then put a reserve beneficiary in. In our customer portal, the first spousal partner simply is a tick box, and then you go through the customer portal as you usually would. The last clause is always the attestation clause, which is a fancy way of saying the signing clause. This clause, which you'll see later on, has a dotted line for the testator to sign, and then a few dotted lines for the witnesses to sign. So it can be fairly easy to sign a will, but you'll be surprised at how many errors are made. Hence why we've created a how to sign your will guide, which is generated with each and every will that the system generates. As I said just before, how to sign a will. So you'll see in front of you here an example of an attestation clause. Here we've got the date. So the date isn't legally required, but it helps with cost and delays in the future, because the probate registry have to prove that this was the last will that the testator had signed. So if you put a date on it, then they won't be needing to do that, because they know it's the last one, because that's the date it was signed. The next part is signed by a testatrix, and here H. Potter has signed their signature. That's all they need to do. They don't need to write their name underneath, because the name's already on the front cover. They don't need to write their initials, just simply their signature. A common mistake is testators seem to think they need to write their name underneath or the date they signed underneath, but they don't need to. If anything, that'll cause issues later on. You'll also see the two witnesses, so witness 1 and witness 2. Here, H. Granger, so the name Hermione Granger, and witness 2, R. Weasley, Ronald Weasley, have signed as witnesses. Legally, you don't need the name, you don't need the address, you don't need the occupation, just a signature is needed, but it certainly helps to have their details there, because later down the line, if there's any issues with the will, if there's any objections, then the probate registry can contact the witnesses to see if the will had been properly signed, or if the testator had any influence from anybody else or was forced to sign it. And lastly, storage of the will. So at HoneyPro, we offer storage for our clients. If we store the will, then the pros of this are we're fully insured. So if the will is lost, if the will is destroyed by any reason because of our error or the staff at the storage centre's error, our insurance will pay out to the beneficiaries. So there's no loss of gifts there. It's complete certainty that the beneficiaries will receive that money. We've never lost a will at our storage facility. So our storage facility is off-site. It's run by a third-party company, and we've used them for a matter of years, and we've never lost a will. So the insurance is a nice to have, and we've never needed it as of yet. So you can provide some peace of mind to your clients because we've never lost a will. Here's an interesting one as well. So if your client decides to not appoint us as executors, so we won't take our 1.95% of the estate when doing the executorship. If we have stored the will, the next of kin of the deceased has to contact us to retrieve the will so they can do the probate process. Now, when we store a will, we send a certificate which says where the will is stored, what the reference number is, what our phone number is, what our email address is, even what our head office address is. So when they call up, they can say this person's died and we need a copy of the will. At that point, that's an opportunity for an upsell of executorship. So our probate team will be able to talk to them. We'll be able to give them free probate advice if needed. And once we gain their trust, then we can suggest us completing the work for them. Because the job of an executor can be arduous, can be long, can be expensive. And we can do it in quite a quick time through our dedicated probate team. Secure and confidential. So our storage is secure and confidential. The certificate that I mentioned before only says that we will release the will to the client themselves if they're still alive, or if they're dead, then to the executor of the will upon production of ID and a death certificate. So we won't release it to anyone else apart from the executor with those requirements. So the ID and the death certificate. On the flip side, if the customer decides to store the will, even if they say I've got a fireproof safe, first things first, fireproof safes are expensive, but also home insurance doesn't cover a lost or destroyed will. You can try and claim against it, but they're just going to say no. On top of that, they won't cover the loss of beneficiaries because they're not the ones who are insured. The client is insured, and the client at this point is dead. The wills are highly likely to get lost by the customer. So there have been instances where our clients have insisted on storing the will themselves, and they've come back to us in a year's time and said, I've lost the will, can you send me out another one? Now, during that time, anything could have happened. And if the will is lost and they sign another one, it should revoke the old one. But if they never contact us, if it's lost, then the executors or the next of kin will have to assume it's an intestate estate. The will can fall into the wrong hands. So a beneficiary who could be excluded from the will could obtain the will. So anyone who has access to the house can have the will, and there's been countless times in other firms where this has happened. They've not stored the will, and the beneficiary has seen that they're only inheriting a certain amount, not happy with it, and just tear it up. And because there's no record of a signed will, then they have to assume that it's an intestate estate and that beneficiary receives more than they otherwise would have. And just to reiterate, anyone with access to the home can see the will. So it's not confidential. Will should only be confidential to the customer until their death. Then it's confidential to the executors. The beneficiaries are not legally obliged to see the will. It's down to the executors whether or not they show the beneficiaries that will. So that brings an end to the wills and intestacy webinar, and the question and answer session will follow soon. Thank you very much for listening.